Hello and welcome to IoT and IP Explained with Claudia Tapia, who happens to be me. In our first episode, we had the chance to talk to Adam Ossoff. Adam is law professor at George Mason University, and he is very well known in the field of intellectual property. I I really like talking to him because he explains very complex issues in a very engaging way. He brings so many examples, so I can truly visualize what he's explaining. And he's also a lot of fun. So I hope you enjoyed our chat, and I look forward to receiving your feedback. And last time we covered copyrights, trademarks, and designs. And we also discussed what is the role that these intellectual property rights could play in the success of the Internet of Things. But we did not have time to discuss in depth neither patents nor trade secrets. So Adam was so kind to join us for a second episode. Adam, if this is okay with you, I would like to start with trade secrets.
Thank you, Claudia. It's a pleasure to be here. Trade secrets are somewhat unique from the other types of intellectual property. Trade secrets, they're kept secret. The Coke formula is kind of the classic example of a trade secret. It was a trade secret for a very long time, and it's still technically a trade secret. So in Coca-Cola's corporate headquarters in Atlanta, Georgia, in the United States of America, they have in a safe there the original formula for Coke. The reality is that the trade secret has long since been, in our term, is reverse engineered. You can actually, on your own, figure out what is a trade secret. You can try to figure it out. And as chemistry knowledge grew, people were able to reverse engineer the original Coke formula. It's why we have Pepsi, and in the United States, Tab, and all these other types of colas. And if you wonder, well, they don't taste the exact same as Coke, that's because that's product differentiation. There's no reason for someone to buy Pepsi if it tastes exactly like Coke, so they make it a little different taste. But that's not technically really a trade secret anymore. We pretty much know what was in the Coke formula at this point. But the 11 herbs and spices in the Kentucky Fried Chicken formula, that actually technically is still a trade secret. People really don't know what's in that. We know generally it's certain spices and certain salts, but the exact ratios and the exact types of spices, it's a little unknown.
In order to be protected, I understand there are some obligations. Like if you put the formula on the desk and where the customers are passing by, it cannot really later on claim as a trade secret.
Right. So for trade secrets, the key is secret. So of the trade secret, trade means it's a commercially valuable idea that you're using in your business, and then secret. So you have to keep it locked in a safe like they do it in the Coke headquarters for the original Coke formula. You have to stamp things confidential or secret or not to be shared. You have to limit access to it, and you have to have what are called non-disclosure agreements. So people have to commit by contract to keeping something secret if they learn about it. And most people, if you look at your employment contracts, because most employees have a standard language in their employment contracts, a provision about exposure to trade secrets and that they're obliged to keep them secret if they are exposed to them at the company. So you're right. So if you have something that's a trade secret and you just put it on a table that anyone can see it, you're going to lose your trade secret because you're not engaging in appropriate efforts actually to protect it by keeping it secret.
We don't want that. That's why we are sharing all this information to the audience so that they can keep it secret if they want to. But coming back to the Internet of Things, can you give us some examples of where you think that companies or just individual inventors might wish to keep a trade secret in this context?
That's a really interesting question because most of the technologies that have driven the internet and computer technology more generally are protected by patents and somewhat by copyright, but mostly patents because these are technological inventions that are deployed into the world and are easily known. if something's impossible to keep secret, you can't keep it as a trade secret. You can't protect it as a trade secret. They call that inevitable disclosure in trade secret law in the United States, at least. I don't know what those specific laws are, maybe in Europe. But patents, one of the distinguishing features of patents from trade secrets is patents are made public. In fact, that was one of the great insights about the patent system. And one of its great contributions to modern society is that people kept things locked up for a very long time. This was the old guild system that used to exist in Europe and even in the early years in the United States. The purpose of the guilds were to keep things secret. And the problem with keeping things secret is information is not shared, and people therefore don't have the ability to build upon it themselves and invent and create and expand the knowledge of everyone in society. So patents provide strong legal protection, what we call in the law the right to exclude. You can exclude someone, like you can exclude someone from your home, from taking your bicycle or taking your computer. But in exchange for that property right, you have to publicly disclose your invention, how to make it, how to use it. And you have to do so the moment the patent is granted to you. So even while it's under protection of the property right, other people can read your patent application. So all the patent offices around the world have databases of all of the patents that they've issued that you can access now on the internet and can read, and people do so, and people then invent on top of that. They create new inventions to further their own commercial activities or technological research, or they do something we call design around. They come up with a competing product, the Pepsi competing with Coke in the trade secret context, as I mentioned earlier. So they come up with a competing product that doesn't infringe, but does something similar. So, and this is all made possible because the information is disclosed through the patent application. It's made public. And so most technologies, because the internet is available to everyone and is used by people and is easily accessible and understood, and same with computer technologies in your laptops and our phones, are really protected by patents. And so patents tend to be the primary driver of not just the innovation that's created in that context, but also means by which this innovation is deployed in the marketplace.
So you have this great idea
Mm-hmm.
and you go to the patent office to file a patent application. You know that after certain months, they will publish it. This is part of the deal. You get this right to exclude everyone. What do you do with that right?
Great question as well. These are fantastic questions.
Oh,
Yeah, so you do the same thing that someone who's given a similar right to exclude when they discover a piece of land that no one owns and is no one's using, and they start to farm it or they build a house on it, right? They have a same right to exclude there where they've engaged in kind of productive creative labors, and the patent system does the same thing. So you don't just sit back and I have my right to exclude and I'm not going to do anything with it. The purpose of the right to exclude, this property right, in fact, that's a modern innovation too, because the very early patent grants about 400 or 500 years ago were really these monopoly privileges that were granted by crown kings and queens and other governments as special monopoly privileges. And it was really a modern innovation that began in the United States and spread throughout the world in the 19th century that no, these should be property rights. Now, why? Well, because a property right is something that you don't just exclude people from, it's something that you engage with people with. Businesses want to sell products to you. They have the property rights to sell those products to you. You want to invite friends and family to your house and have dinner with them. You want to exercise your rights of property by allowing them to come into your home. And patent owners do the same thing with their inventions. They go out into the marketplace and they can use their property right to either manufacture and build their inventions, or they can enter into contracts, we call them licenses in intellectual property law, with other people to build and manufacture their products. They can enter into licenses for other people to sell their products. Now, this is a really key, important insight because we call this in economics division of labor or specialization. This was the key insight by Adam Smith with his very famous book, The Wealth of Nations in 1776, that it's division of labor and specialization that is facilitated by property rights and contract that allows for the explosion of the production of value in society. And this is exactly what we've seen the past 200 years when people are protected to the rule of law and their rights of property, contract, and even liberty and bodily integrity, that they then have the freedom to engage with other people and specialize. So I can teach and other people can practice law and other people can become experts in plumbing and building houses, and we trade with each other. And patent owners with their inventions do the same thing. So some people are really good at invention, but they're not good business persons. So they should just invent. For instance, Charles Goodyear, who invented rubber, did that. So he invented the process of rubber. He was a crazy inventor. He just loved rubber, wasn't a good business person. So he licensed to other people to manufacture and produce his rubber. Thomas Edison did some very similar things when he invented some of his very famous technologies.
Excellent examples. I'm thinking about one of the investors we invited for Epic Council to talk about SMEs, startups. And one of the first thing they always looked at was intellectual property.
Yes.
If they haven't protected the ideas, they will not support them financially because they wanted to make sure that they have a time, in this case with patents, 20 years typically, where they have this advantage, where they can be the only ones dealing with that technology. So I think it's extremely important. And I've seen it also from large companies, how they put their IP very present because they understood that this is relevant for their reputation and how it shows the innovation that they are going through thanks to the intellectual property.
Yeah, it's in fact, in the United States, it's now been proven. There was a study that was done by an economist at New York University in New York City a few years ago with United States patents, where they have now actually proven as an economic matter that having a patent for a startup more than doubles the chances of that startup receiving venture capital financing. And that's really significant and important, because it's the very first time that this type of causal relationship has been shown between economic activity and patents. And it's because it's very hard to separate out all of the various influences that may be occurring in the marketplace and society more generally. But in the United States, when I give talks, I often remark to people, you see this, you don't need economics or an economic study to tell you this. You see this every day in the United States in a very popular show we call Shark Tank, where inventors present on TV to some venture capitalists their new ideas. And one of the very first questions the venture capitalists always ask is, do you have a patent? And sometimes they don't. And they said, I can't believe this. You just went on national television and gave away your idea to everyone. Why should I invest in you now?
But this is a very important point that you just raised. Before you share to anyone, you file a patent applications. And if you need to share, then you have a non-disclosure agreement. And what else do they need to consider? Those that as requirements for a patent applications?
Part of that shift from monopoly privilege that I talked about earlier to patents was the recognition that, well, these are property rights in newly created inventions. So you can't be giving it for something that already exists. That is a monopoly because then you are taking away people's pre-existing rights in property and contract if they already have the idea, if they already have the technology. So they quickly formulated over the span of several decades, starting in the 18th century through the 19th century, some various legal requirements for what would make a patent a valid property right. It has to be new. Our term in patent law is novel. So it can't be something that pre-exists because if it is, then you're being given legal rights that take away other people's rights, and that's not the function of a patent. So it really does have to be a new invention. Um, so you need to make sure that you've studied patent grants already. That's one reason. Another reason why it's important that they are in these publicly accessible databases. So you can always check to see if you have a new invention. It has to be useful. It actually has to be something that you can use in the real world. It can't just be some type of broadly framed, generalized idea that you don't really have an application for yet. So it has to be an actual thing, like a smartphone or 5G, or it has to be, you have to fully disclose it in your patent application because that then becomes published. So it wouldn't work. The publication and the sharing of information wouldn't work if you keep things secret. So you have to fully disclose your invention in your patent application and becomes part of the patent issues. And so that means not just describing it, but your description of it has to inform people how to make and use it. That's vitally important because then people can test it even during the time it's under patent and figure out how to design around it, create competing products or how to build on top of it. There's 3G, so we want to make 4G and then 5G. But then even more importantly, when it does eventually go off patent after the term of protection ends, because it's always a limited term from which you have protection, um, it falls into what we say the public domain, then it has to be something then that people can use and figure out how to use it. Now, last but not least, is a very difficult area of patent law that we call non-obviousness. And in the United States, I believe it's called the inventive step. In Europe. And this is a really tough area. So this is an area of patent law where we say, okay, it is new, it's useful, and you fully disclosed it. But to someone who knows and is skilled in that particular field of technology and computer science or electrical engineering or microbiology, it's obvious. It's an obvious next step. That's why they call it in Europe the inventive step. It really has to truly be an inventive step. The example that I sometimes use with my students is someone invents the bicycle, which actually was patented in the United States in the mid 19th century. And then someone says, "Oh, well, you have invented a bicycle. I've invented now the tricycle." Now, the tricycle would be new. It would be three-wheeled device as opposed to a two-wheel cycle device, and it would be useful. It's very useful if you have small children because they don't know how to balance on bicycles yet. So tricycles are very helpful for them, and you can fully describe it. But someone would say, but for someone who's a mechanical engineer or who's skilled in how to make and use bicycles, it's an obvious step just to add a third wheel. And so that wouldn't get a patent. That's kind of a classic good example of an obvious invention. And we don't want to protect obvious inventions because the value in the property right is very strong as this right to exclude. And the point is that yes, this is a new invention. The tricycle is a new invention, but it's not that much of a significant step forward that justifies the strength and protections that come with the patent interest. And so we're trying to balance the interests here between kind of the rights of the public and the rights of other people who are skilled in that field to continue to make and do things that they would be expected normally to do because things are obvious to them or it's a next logical step to them versus true inventions that are leaps forward that we do want to protect and we do want to incentivize people to create.
I've seen, by the way, that you upload from time to time post in your LinkedIn account with patents. Yes. I love that. From time to time, I'm like, oh, that was patented. Yes. You didn't know about.
Yes. I started on Twitter, now X, these posts about 10 years ago or 12 years ago called On This Date in Innovation History that I share then on LinkedIn, where I identify anniversaries in history when patents have issued on various things. And one of the reasons why I did this was because the patent system, in a certain sense, is a victim of its own success. The patent system, the modern patent systems that started in the United States and then eventually went to Germany and England and other places, have been so successful in uh, promoting people to invent, getting people to file for patents on those inventions, publicly disclosing information, and then being used as property rights to go into the marketplace to create and sell these products, that uh, they're in everything and people don't realize they are. And so we often hear of the problems with patents and we don't realize how much of the valuable things that we actually use in our lives, everything from our toothpaste tubes to our dolls. Raggedy Ann doll was patented, to our games. The Monopoly board game was patented. Um, everything, forks and knives and tractors and motorcycles, component parts, and all these things were at one point or other patented and protected. And it's exciting to see sometimes, as you mentioned, like, oh, I didn't realize that was patented. Yeah, so a lot of people didn't realize the Raggedy Ann doll was patented, or the Barbie doll
Yeah.
was patented, actually. Given the recent Barbie movie.
Yes, I was thinking about
Yes,
that.
and so it's been fun to do this, and it's been fun to see people have very positive reaction to it.
Mm. And in that case, because patents, it's very linked with technologies, this I assume will play a huge role in the success of the Internet of Things.
Yes. Yes. I mean, so patents have been a driver of every major technological revolution. So patents were a driver of the Industrial Revolution. So what they used to call dynamos, and we would now call electric motors, to combustion engines, to oil derricks and light bulbs and electrical distribution systems from Thomas Edison and Nikola Tesla and others were all driven by patents, both in securing the inventions and in serving as the basis for the contracts and commercial activities to make them available in the marketplace to consumers. Then the pharmaceutical revolution of the 20th century starts in Germany, but then shifts eventually to the United States, and again, driven by patents. And there, it's very important because of the extensive investments in time that are necessary to discover new drugs. You really do need that protection for them to recoup what is now 2.6 billion US dollars on average that a pharmaceutical company invests before they receive a single dime from the first sale of the new drug. And so they have to recoup that plus fund all the ongoing research that they're doing. To, of course, the computer revolution. So the integrated circuit that was invented by Jack Kilby and Bob Noyce, independently of each other in the United States in 1957, which leads to the microchip, which leads to computer technology and personal computers, is driven by the patent system. The internet. A lot of people think, oh, the internet's free and everything's available and open on it. Actually, no, patents underlie it. Google got a patent on its original search algorithm in 1997. I highlight that in my The State Innovation History. And of course, the mobile revolution. And then the next revolution, the Internet of Things. And the Internet of Things is going to be a series of important technological innovations that are based in, my understanding, what will be hundreds of billions of US dollars of research and development by companies like Ericsson and Qualcomm and NerdDigital and Apple and all these companies in developing not just the wireless, communication technologies, 5G and things of that sort, but also even the technologies in the devices that will be able to facilitate the connection with consumer products. And so if you think about the integration of all of these incredible technologies, that itself involves additional creation of new technologies. This will require people to make incredible investments to create those technologies, to protect those investments as property rights through the patent systems, and then to use those property rights to enter into the licenses and deals in order to facilitate the creation of all these incredible new technologies that will eventually interconnect all of our products and services in our homes, in our offices, in our cars, and in ways that frankly are probably unimaginable to us, because if you had even said to someone 20 years ago that we would have these types of technologies and we would be doing certain things on our things that we call our phones, which are really supercomputers that we call phones still, that was science fiction even 20 years ago.
I was a kid and we moved to Spain.
Hmm.
We used to write letters to
Yes.
Argentina, and it took 1 month to arrive. And when we were calling, which was very exceptional because extremely expensive at that time, I recall we were all chatting. The voice, the calls were disrupted, and
Hmm.
so now when I see my mom talking to the brothers and sisters, or I with my cousins and family, just spontaneously, it's unbelievable.
Yeah.
And how we managed to get people connected. So it's truly impressive. And as you said, it's difficult to imagine because
Hmm.
we are all the time surprised by these amazing technologies.
Irwin Jacobs, the founder of Qualcomm, the inventor of the technology that goes by the initial CDMA. That's our
Mhm.
2G, 3G, 4G. G is just generation, the
Yeah.
next generation of CDMA. You know, in interviews, he has said this. He said, when people have asked him, "Did you foresee this incredible mobile revolution, what we now call the mobile revolution?" He said, "No." In 1987, when we were developing this technology, we thought we were going to just trying to make it easier for companies to do video conferencing. And he said, I never foresaw, people watching movies, emailing, using GPS, or sharing cats riding Roombas on videos on these devices, on these supercomputers that we carry in our pockets now. And this is classic issue, as you said. People can't imagine what new areas of activity and possibilities are opened up by innovations. Like Thomas Edison thought when he invented the record player, what he used to call the phonograph. So the older people, these were these vinyl discs that we used to listen to music before MP3s came along. He thought this would be used by businesses to transmit information. So a person in company X would record a memo or a letter to someone on a record player, would hand it to a courier who would carry that record to another company Z, who would then play it for them. Alexander Graham Bell, when he invented the telephone, he thought telephones would primarily be used for people to listen to concerts, to music. So he thought, oh, people don't have to go to concert halls anymore to hear concerts. We can run wires and transmit the music to people's homes. And so people will sit in their homes and listen to music. So what ends up happening, though, is record players end up being used for music, and telephones actually end up being used for business persons to quickly transmit information. So, yeah, inventors and innovators themselves often don't see where their inventions will be deployed in the marketplace and be used to the benefit of consumers. And that's the importance of patents as property rights, is that that's what gives the people the ability to develop these new ways of using them and deploying them through their own specialization and their own capabilities.
Thank you, Adam. Unfortunately, we are out of time for today. For those of you listening, I hope you now have a much better understanding of trade secrets and patents and the role they play in the IoT. In our next episode, we have the pleasure of speaking with Valeria Silva. She is, among other things, Senior Advisor on AI related issues for none other than the OECD. We will be discussing generative AI, IoT, and copyright. As always, we very much welcome your suggestions and feedback. You can reach us on LinkedIn at Claudia-Tapia or on Instagram at IP with Claudia Tapia. I send you a big hug and all my best wishes for the coming weeks. See you in a month.